Law with Dr. Mithun. I hope you will definitely support this live video as you supported all other videos of this channel. This is my only second attempt of making this live session. So I welcome you all again on this particular channel. So today we'll discuss about a topic of temporary injunction and what procedure actually given under the civil procedure of this particular temporary injunction. So let's start with the temporary injunction and its procedure. Now first, injunction is a kind of a relief or remedy which is provided basically in the civil suit, and this injunction is nothing but it is an order of a court either to do or not to do something. So by this order, court is actually restraining a party, or court is actually allowing a party to do something or not to do something. That is called as an injunction. Now there are two basic injunctions. One is temporary injunction, which is of we are going to discuss in this live video, and another is permanent injunction. Now there are two laws, one that is Specific Relief Act and another that is Civil Procedure Code. So when we see the Specific Relief Act, in that Specific Relief Act we find the provisions which deals with the permanent injunction, whereas under the Civil Procedure Code, Order 39 deals with the procedure of temporary injunction. But naturally, as I told you, what is injunction? So temporary injunction is of temporary nature. You can say till the disposal of the suit. The injunction which granted by the court of law, that is known as a temporary injunction. And the permanent injunction is an injunction in which the court grants that injunction for indefinite period permanently in favor of the party who is claiming that permanent injunction. So today our topic basically only with regard to the temporary injunction, and so in this video we are concentrating on Order 39 of Civil Procedure Code and the rules with reference to Order 39 under that Civil Procedure Code. So Order 39 Rule 1 to 5, that basically empowers the court to pass an interim relief for protection of property. And under this order, we understand that injunction is basically a judicial process whereby a party to the suit is required to do or restrain from doing any particular act. Then that is something what we are understanding as an injunction. And so in this we understand that injunction in the temporary nature can be of mandatoriness also. So there is a category which is known as a temporary mandatory injunction, in which court issues the order that till the disposal of the suit a particular party is compelled or required to do any particular act. Then that is something what we are understanding as a temporary mandatory injunction which is issued by the court against that party. And when we understand in general as a temporary injunction, it is something like an order of a court which is restraining a particular party from doing a particular act, in which a status quo also we understand. Court is expecting that a particular situation should be kept as it is, or particular circumstances with reference to a subject matter of that particular suit should kept as it is without any interference. And so status quo is kind of an interim relief which is given against both the litigants, both the parties to the suit. So these are the different categories in which we are understanding that temporary injunction. And all these are the interim reliefs, interim injunctions, we can say. And they are, whether applicants they are coming with that particular relief, court either accept that claim and they grant that relief, or court either reject their claim and they rejected to grant such particular interim relief. Now whenever there is a effect of that particular grant of interim relief, we understand that as it is a temporary relief, the duration of that particular relief is a very determined, is a very certain, that till the disposal of that particular suit, that temporary relief will exist. Once a suit is decided, that reliefs and that temporary relief comes to an end. That first we need to understand. And so it is expected that if you are claiming the permanent injunction by filing a suit, it is expected that in that particular prayer of the permanent injunction, you must incorporate a prayer of temporary injunction, so that if suppose temporary injunction granted in favor of that particular applicant, that temporary injunction if granted along with the main prayer of permanent injunction, then automatically that temporary injunction will be converted into the permanent injunction by the court of law. And so without claiming the temporary relief, court is not authorized to grant you that temporary injunction in a particular suit. So it is expected that the party who is coming in the court of law and party who is expecting that the court of law should grant temporary relief in his favor, that party must expressly claim that particular relief from the court of law. If the party is not claiming that temporary relief, then court cannot grant that particular relief in favor of that particular party. And so this thing you must understand with reference to the temporary relief. Now for obtaining such particular orders, as a procedure, first there is a need of application. And now this application must be made along with the affidavit and other supporting documents, whatever require. Evidence of supporting witnesses, so as to satisfy the court that a prima facie case exists in favor of the plaintiff or defendant. The balance of convenience lies in favor of plaintiff or defendant. And lastly, irreparable loss would be caused if injunction is refused to the other party. These very basic 3 points shall be sufficiently shall be sufficiently incorporated in the application of claiming that particular temporary relief. So first, that you must satisfy the court that the prima facie case is exist in your favor, and for that reason court must grant that temporary relief. Second, that the balance of convenience lies in favor of you, and if court is not granting this temporary relief, then it would be a very inconvenience for you. Even that also you satisfy to the court. And third, if this temporary relief would not granted in favor of you, then irreparable loss would cause to you. So these 3 points becomes a very crucial points with reference to the application of a temporary injunction. And so these consider as a very basic and necessary points of consideration in injunction application, what we are understanding. And these 3 points must be specifically, certainly reflected in the pleadings when we are claiming that injunction or temporary injunction. If your application is not with these 3 basic points, or your pleading is not sufficiently mentioning these 3 basic points, your application, your suit, your pleading cannot survive before the court of law. And so the relief like temporary or permanent injunction, they are basically covered in section 38 to 42 of the specific relief act. Sorry, when we are talking about the permanent injunction, we understand that the sections from section 38 to 42 of the specific relief act, they covered the injunctions, that is temporary and permanent injunction. But when we see the temporary injunction in civil procedure code, we have to specifically understand order 39, and in that rule 1 to 4 of the civil procedure code. Under this order 39, we find that when we are preferring the application for temporary injunction, order 39 provides a grounds on which you can prefer that particular application of temporary injunction, in which basically we understand whenever there is a reasonable apprehension and danger of alienation or disposal of property by the party to the suit, or by wrongful waste of the property, or when there is an apprehension of alienation or disposal of the property with a view to defraud the creditors, or where defendant threatens to dispossess plaintiff or otherwise causes injury to the interest of plaintiff in relation to the disputed property, or when the defendant is about to commit breach of contract or any other injury which is likely to be caused or likely to be repeated, or where the court is of the opinion that for the protection of interest of any party to the suit or in the interest of justice, injunction or stay status quo is required and necessary. These are the basic grounds, basic conditions in which temporary injunction under order 39 can be granted by the court of law. Now this injunction as a relief is based on the principle of equity. And so when we see the principle of equity, we understand that the equity good conscience. These are the principles of fairness. And so, it is expected that one who claims equity must do equity. One who claims equitable relief must come with the clean hands. And there should not be any suppression of any material fact. There should not be any misleading of fact to the community. Equal opportunity of hearing must be given to all the parties to the suit. There cannot be application of equity against law. So these are the equitable principles, and that's supposed to be followed by the parties to such particular litigation in which they are claiming temporary injunction or in general injunction before the court of law. And so at the time of making the application for the temporary injunction or injunction in general, or during the submission for relief of temporary injunction, the party must have, the party must undertake to the principles of equity what we just understand. Now the relief of injunction is different from the relief of stay, what we understand in general in the civil proceedings. As we understand, the relief of injunction is claim against the party, against the opposite party, whereas stay is basically addressed to lower court or to the subordinate court by the higher court as a procedural requirement. So in the stay we understand, whenever there is a necessity to prevent a particular act which is not in existence before the application is made, then the relief like a stay can be used in that particular civil proceedings. But when we see the relief claim in which there is an apprehension of danger and that danger is likely to be caused, then it is necessary to prevent that particular apprehension. If the other party is threatened to protect the property from that particular threatening, the injunction or the interim relief can be granted by the court of law. Order 39, Rule 1 and 2 under section 151 of the Civil Procedure Code. Under these provisions, the injunction and the stay both can be asked to the court of law. So stay is granted against the court and against the parties to the suit, whereas injunction is granted only against parties and not against the court itself. So these are the basic things that we can understand with reference to the temporary injunction and the procedure of that particular temporary injunction in the court of law. So I hope this live session will help you, and definitely it will enhance your knowledge about the procedural aspect of temporary injunction. So thank you very much for supporting, for joining this particular live session. If you enjoy this live session, if you understand this live session, this learning process, keep supporting, and I would be happy to know your responses. So you can comment about this particular live session. Thank you for supporting me and this channel Shine in Law. शेयर करो, सब्सक्राइब करो और इस चैनल को सपोर्ट करो. So once again, thanks to all of you. So I am now stopping this particular session. Thank you very much. Thank you.